start. It remains to be considered whether the respondent is not right when he contends that in the circumstances of this case, the conclusion of the government is based on no evidence whatever. Stop. It is conclusion which is perverse and therefore suffers from such an obvious and patent error on the face of the record that the High Court would be justified in quashing it. Stop. In dealing with writ petitions filed by the public servants who have been dismissed or otherwise dealt with so as to attract Article 311, the High Court under Article 226 has jurisdictions to inquire whether the conclusion of the government on which the impugned order of dismissal rests is not supported by any evidence at all. Stop. It is true that the order of dismissal which may be passed against a government servant found guilty of misconduct can be described as an administration order. Nevertheless, the proceedings held against such a public servant under the statutory rules to determine whether he is guilty of the charges framed against him are in the nature of quasi-judicial proceedings, and there can be little doubt that a writ of certiorari, for instance, can be claimed by a public servant if he is able to satisfy the High Court that the ultimate conclusion of the government in the said proceedings, which is the basis of his dismissal, is based on no evidence. Stop. In fact, in fairness to the learned Attorney General, we ought to add that he did not seriously dispute this position in law. Stop. He, however, attempted to argue that if the appellant acted bona fide, then the High Court would not be justified in interfering with its conclusion, though the High Court may feel that the conclusion is based on no evidence. Stop. His contention was that cases where conclusions are reached by the government without any evidence. Stop. His contention was that cases where conclusions are reached by the government without any evidence could not in law be distinguished from the cases of malified, and so he suggested that perverse conclusions of fact may be and can be attacked only on the ground that they are malified, and since malifieds were not alleged in the present case, it was not open to the respondent to contend that the view taken by the appellant can be corrected in writ proceedings. Stop. Over.